5 seconds to go. Start. The next point was with regard to consent or sanction. There is no doubt that in respect of BP Sinha, consent was properly given by the Deputy Commissioner. So, consent was also given in respect of N.K. Banerjee and Harihar Prasad by the Chief Secretary. This is not a case of sanction or consent under Section 196A of the Code of Criminal Procedure. On the question of the applicability of Section 197 of the Code of Criminal Procedure, the principle laid down in two cases, namely Shri Kantai Ramaiya Munipalli versus State of Bombay AIR 1955 SC 287 was as follows. It is not every offence committed by a public servant that requires sanction for prosecution under section 197(1) of the Criminal Procedure Code, nor even every act done by him while he is actually engaged in the performance of his official duties, but if the act complained of is directly concerned with his official duties so that, if questioned, it could be claimed to have been done by virtue of the office, then sanction would be necessary. The real question, therefore, is whether the acts complained of in the present case were directly concerned with the official duties of the three public servants. As far as the offence of criminal conspiracy, punishable under Section 120B, read with Section 409 of the Penal Code 1860, is concerned, and also Section 5(2) of the Prevention of Corruption Act are concerned, they cannot be said to be of the nature mentioned in Section 197 of the Code of Criminal Procedure. To put it shortly, it is no part of the duty of a public servant while discharging his official duties to enter into a criminal conspiracy or to indulge in criminal misconduct. Want of sanction under section 197 of the Code of Criminal Procedure is therefore no bar. In B. Saha and others versus M.S. Kochar, reported in 1979 for SCC 177, the appellants were charged for the offences under sections 409 and 120B IPC. The court opined that while it is not an invariable proposition of law that the act of criminal misappropriation or conversation cannot be inseparably intertwined with the performance of the official duty, yet in the facts of the present case, the alleged act of criminal misappropriation could not reasonably be said to be imbued with the color of office or having a direct connection with the duties of the appellants as public servants. Therefore, sanction was not considered necessary. While observing so, the court stated that the expression any offence alleged to have been committed by him while acting or purporting to act in the discharge of his official duty must neither be construed narrowly nor widely, and the right approach would be to arrive at a balance between the two extremes. Therefore, the sine qua non for the applicability of this section is that the offence charged, be it one of commission or omission, must be committed by the public servant either in his official capacity or under the colour of the office held by him, such that there is a direct or reasonable connection between the act and the official duty. The relevant observations are as thus. The words any offence alleged to have been committed by him while acting or purporting to act in the discharge of his official duty employed in section 197(1) of the code are capable of a narrow as well as a wide interpretation. If these words are construed too narrowly, the section will be rendered altogether sterile, for it is no part of an official duty to commit an offence and never can be. In the wider sense, these words will take under their umbrella every act constituting an offence committed in the course of the same transaction in which the official duty is performed or purports to be performed. The right approach to the import of these words lies between these two extremes. While on the one hand, it is not every offence committed by a public servant while engaged in the performance of his official duty which is entitled to the protection of section 197(1), an act constituting an offence directly and reasonably connected with his official duty will require sanction for prosecution under the said provision. As pointed out by Ramaswamy Judge in Bajnath vs. State of MP AIR 1966 SC 220, it is the quality of the act that is important, and if it falls within the scope and range of his official duties, the protection contemplated by Section 197 of the Criminal Procedure Code will be attracted. In sum, the sine qua non for the applicability of this section is that the offence charged, be it one of commission or omission, must be one which has been committed by the public servant either in his official capacity or under colour of the office held by him. This court in State of Maharashtra versus Dr. Buddhi Kota Subba Rao reported in 1993 3 SCC 339 elaborated on how the balance between a narrow and wide construction of section 197 CRPC can be maintained. The court opined that the section must be construed strictly while determining its applicability to any act or omission in the course of service, and its operation has to be limited only to those acts which are discharged in the course of duty. However, once any act or omission has been found to have been committed by a public servant in the discharge of his duty, then a liberal and wide construction can be given to the particular act so far as its official nature is concerned. For instance, a public servant is not entitled to indulge in criminal activities in the discharge of his duty, and to that extent, the section must be construed narrowly and in a restricted manner. However, once it is established that the act or omission was done by the public servant while discharging his duty, then the scope of it being official should be interpreted such that the objective of the section is advanced in favor of the public servant. In R. Balakrishna Pillai versus State of Kerala and another, reported in 1996 1 SCC 478, the appellant, who was the then Minister for Electricity for the state of Kerala, was alleged to have entered into a criminal conspiracy to sell electricity to an industry in the state of Karnataka without the consent of the government of Kerala. The court stressed that the quality of the act must be looked into, and there can be no general proposition that whenever there is a charge of criminal conspiracy levelled against a public servant, the protection under section 197 CRPC would have no application. The question of whether the act complained of had a direct nexus with the discharge of official duties would depend on the facts of each case, and it was stated as thus. The question whether the acts complained of had a direct nexus or relation with the discharge of official duties by the public servant concerned would depend on the facts of each case. Stop.